Okay, we're going to get started now, so thank you all for coming. If you haven't gotten pizza already, feel free to do so. Just to open up, the Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. The title of today's topic is the Confederate Flag, Treason, or Liberty Symbol. For the format today, we'll have both our speakers speak for 15 minutes, and both will have 5 minutes to respond or comment to each other. And then at the end, if we have time, we'll have Q&A, so please be thinking of any questions you may have. To introduce our speakers, Professor John Kunich is a professor at the University of North Carolina at Charlotte. He earned his JD from Harvard Law School and his LLM in environmental law from George Washington University School of Law. He also earned his Bachelor and Master of Science degrees in biological science from the University of Illinois. He was born and raised in Chicago. He was also a Fulbright Senior Specialist and a professor of law at the Indian Law Institute. He was born and raised in Chicago and has taught summer courses in China for 3 years. Professor Sheldon Nahmod is a distinguished professor of law at Chicago-Kent College of Law and a well-known expert on constitutional law, civil rights, and the law of Section 1983. He graduated from the University of Chicago and Harvard Law School. He was a teaching fellow at Harvard Law School. He is the recipient of the Jefferson Fordham Lifetime Achievement Award for his work in Section 1983. After joining Chicago-Kent, he served as an associate dean for 3 years and was named IIT Distinguished Professor in 1992. He founded and for many years co-directed the Institute for Law and the Humanities. Please join me in welcoming our speakers.
Well, thank you very much, and especially thank you to Professor Nahmod for taking some of his scarce time to be here today. I don't like controversy, and it really upsets me, so I picked a very bland, plain vanilla topic. But thanks for coming anyway. I know it was the pizza. It certainly wasn't me. But what we're going to talk about for a few minutes today is a First Amendment issue that I think is ideally situated to highlight some of the key facets of the First Amendment. After all, if speech is not controversial, you don't need to protect it. The speech that needs protection is precisely the kind that's inflammatory, polarizing, divisive, etc. And what better example currently than display of the Confederate flag? Now, the usual caveats, trigger warnings, disclaimers, etc. I am not here advocating that people should display the Confederate flag. What I'm here to argue is that it should be considered protected speech so that the government should not be able to ban it, to suppress it. Basically, that is my main thesis today. So I'm going to go through a little bit of a background on what the First Amendment protections mean in the symbolic speech category, and then we'll talk a little bit about the 3 main exceptions to the usual First Amendment protections that I think the Confederate flag arguably fits within so that it would not be protected. We'll go through each of those, and then we'll conclude. This is going to be sort of a hurry-up offense because this could easily be several days' worth of material, but we're going to do it all in less than an hour. So fasten your seatbelts. Okay. Basically, the First Amendment. I don't know how many of you are battle-scarred veterans of constitutional law, but just in case you're not, you read the First Amendment, it looks like it's absolute. Congress shall make no law abridging the freedom of speech or of the press. It's like the old joke, what part of no don't you understand? Well, apparently quite a lot, because even back in the day when they were discussing the Constitution, there were examples where the government was allowed to punish speech, where it could be suppressed, where people who are expressing thoughts could be imprisoned for them. And so even back in the 18th century, no law didn't really mean no law. And so there are typically several court-recognized exceptions to the seemingly blanket protection that the First Amendment provides. Focus on the 3 that seem most likely to embrace the Confederate flag. Treason. The only crime that the Constitution actually explicitly provides for is treason, being a traitor to your country, and it gives a little bit of detail on that. So clearly, if you're going to be committing treason, that's going to typically involve communication, working with co-conspirators, trying to drum up support amongst other people. Let's rise up, let's throw off this government. That kind of thing is going to typically involve a lot of speech. So that's one possible exception. If display of the Confederate flag could count as treason, then it would not be protected. The other two likely exceptions, fighting words based on the case of Chaplinsky v. New Hampshire, and incitement to imminent lawless conduct under Brandenburg v. Ohio. Both of those also are arguably applicable here, so we're going to talk about those. The other ones, obscenity, defamation, clearly don't apply. So let's see a little bit more about what we're going to talk about. One important point is, why might people display the flag? What would be the message the speaker is trying to convey by displaying it, by wearing it, by putting it on their bumper, etc., as well as what would be the likely messages that an observer would take away from seeing it, because both could be important, right? And so here are some possibilities, some reasons why people might display the flag. Perhaps in the most obvious sense, the South was right. The South will rise again. Save your Confederate money, boys. It's going to come in handy. You could show some support for slavery, for white supremacy. That's one possibility. Another, well, maybe people like the idea of secession. You should be able to split off from the Union. Maybe people are members of a current separatist movement, modern day secession, they want to split off, or sort of the close cousin of secession, nullification, taking a vote at the state or the local level to carve out an exception from federal law for yourself. Possibly the display of the flag could be used as an emblem for those things. Another one, question authority. You identify yourself as a rebel, and so part of your self-identification includes displaying the Confederate flag just to show what an iconoclast, what an independent thinker you are. The fact that you dress the same as all other rebels is beside the point. You're a rebel, this is how I prove it. Another one, maybe you have a family history rooted in the Civil War, and for whatever reason, accident of birth, where the person was from, you have a great grandfather or somebody like that who was in the war on the side of the South. And maybe they didn't particularly have any affinity for the political beliefs of the South, but that's the side that drafted them. There were a lot of people in the Civil War who were drafted, conscripted into service on the side of the North and the South, so it's really not legitimate to ascribe any particular racial or political beliefs to the fact that somebody fought in the war on either side. Maybe they were just unlucky enough to have their number come up. And so somebody might want to display the flag to honor great whatever, keep their memory alive. Another possibility, I like this one, a sense of artistic style. It looks cool, right? This one I would lump in with those people who wear or display Che Guevara's face. I would bet you, given my rather dim view of the state of American K-12 education, a lot of people who wear Che's face on their chest have no idea who he was or what he believed. I don't think by displaying his image they're saying, yeah, I like mass murdering communists. I want to be one someday. So I'm displaying his, no, this guy was rocking that look. He was a good-looking guy, right? And so they just do it because it looks cool. Somebody might display the stars and bars for the same reason. It's got a real style sense, right? All right, that kind of thing. All sorts of reasons why people might display the flag and messages people might derive from seeing it displayed. Okay, so let's talk a little bit about secession. What does the Constitution actually say about the right to secede or the absence thereof? Well, unfortunately, nothing, really. The Constitution is completely silent on any right to secede. It has provisions for adding more states to the Union and even for subdividing existing states, but it's completely silent on whether you can secede. It doesn't say you can, and it doesn't say you can't. So what do you do in that kind of situation? One possibility is, well, if it's not affirmatively prohibited, it's allowed. Another possibility, if it doesn't affirmatively say you can, then you can't. or maybe something in between. Well, what do we do? I mean, you can look to the 10th Amendment, for example, and the 9th Amendment for that matter, and see what they say. This is what the 10th Amendment says, and, well, one thing you might conclude from that is there anything in the Constitution that delegates the gateway to secession to the federal government? No, it doesn't say anything at all. Is there anything in the Constitution that prohibits the states from seceding? No, not really. Well, then based on that, you might conclude from the 10th Amendment that power is reserved to the states to conduct some democratic process and vote on it, or to the people themselves. But if you haven't been to con law yet, you always want to like channel James Madison. Jimmy, come here. Can you clarify this? Dude, what do you mean by this? Can you be more specific? And I've checked. He's not coming today. So we're left here to muddle through as best we can. You would just love to ask him, though, what do you mean? Would that include secession, since it doesn't say anything about it one way or another? Ninth Amendment too, the unenumerated rights. Don't conclude from the fact that the Constitution doesn't specifically list a particular right that it doesn't exist. This isn't the whole list. These are examples. Of course, you always have the question, well, if there's unenumerated rights, what are they? And the answer is, who knows? If they were listed, they wouldn't be unenumerated. You have to sort of wait and see. Does a court recognize an unenumerated right? Like marriage, like reproductive liberty. It says nothing about it. You might have to wait centuries for a court to say, oh, by the way, here's this right. Okay, 9th and 10th Amendment. Mr. Madison, really, what did we ever do to you? Anyway, now what can we conclude from the historical record? Well, you have sort of anecdotal evidence. James Madison, who of course was the primary author of the Constitution, made some statements that he didn't think there was a right to secede. Thomas Jefferson, the primary author of the Declaration, other than the parts that he stole from John Locke, said, on the other hand, he thought there was a right to secede. Okay, you got a little bit of pedigree on both sides. Surprisingly, there was a significant secession movement in this country before the Civil War, but it wasn't from the southern states. It was mostly the New England states. They were considering voting to secede for the opposite reason that the Civil War was precipitated. They objected to things like the Fugitive Slave Acts. As you probably know, there were federal laws that said if a slave escapes and makes their way to a northern state and they come into contact with somebody in those states, that person must return them to their so-called owner under penalty of law if they don't. And the New England people would say, are you kidding me? If a slave happens to be brave and lucky enough to work their way up here, we're not turning him in. We're not doing that. And if you insist that we have to, we're going to vote to get out of this country. This is not the kind of country we want to belong in anymore. So they assumed there was a right to secede. It never came to a boiling point. They managed to calm the crisis down, but there were a lot of abolitionists for secession. Interesting. And so you had three views pre-Civil War. Some, like the abolitionists, thought there was a constitutional right to secede. Doesn't say you can't, so you can. There were some who thought, well, maybe it's not quite in that category, but maybe it's like how we started our country in the first place, a right to revolution. A long train of abuses and usurpations can lead up to a right or even a duty to throw off the old government and form a new one. Maybe it's revolution. Another view, treason. You can't fight against your own country. You can't split off from your own nation. That wouldn't be a union at all. It'd be too unstable. So no, it's like Hotel California. You can check out, but you can never leave. All right, so three possibilities. Well, little known fact, and the hits just keep on coming. There's no extra charge for this, by the way. But if you ever are bored and you're going to go to a party and you want to really stir up some controversy, talk about these ordinances of secession. When you're at the party, say something like, have you ever read into the ordinances of secession? They're really quite fascinating. And just look at their facial expression. Number one, you'll never be invited to another party. So that's good. It gives you more time to study. Right? But every state, all 13 of the states that voted to secede, decided that there must be some sort of democratic process involved. So in one form or another, they all had votes within their states to say, should we secede or not? Some made it a referendum, some did it with the whole state legislature, some with a portion of the state legislature, but they put it to a vote, and in 13 states the vote was in favor of seceding, and then they would adopt an ordinance documenting that. And it's sort of cool, if you look at this website, it has the full text of all the ordinances of secession. Which, by the way, it's a cool word, isn't it? It's like something the Voltaire from Twilight would come up, these are the ordinances of secession. Whoa, it just sounds important, doesn't it? So look them up. You can amaze your friends and confound your enemies on that. Now, if you look at the ordinances of secession, a few of them, I think 4 out of the 13, explicitly mentioned the right to slavery as their reason for seceding. The others didn't. They just left it at something like states' rights, federalism, self-determination, etc. But clearly, Abraham Lincoln's election to the presidency on an anti-slavery platform was a precipitating event that led to the secession votes. This is just an image of the Republic of Georgia's Ordinance of Secession. And I don't know, I come up with these things myself all the time, giving myself titles, various dukeships, and they're completely invalid, of course, but they make good things to hang on your wall. Now, surprisingly, the Confederate flag, it wasn't just one flag. The one that we're all familiar with is this guy here, but that's really just the flag of the Army of Tennessee, the section of the Confederate Army that included Nathan Bedford Forrest, for example. The Army of Northern Virginia that featured Robert E. Lee and Stonewall Jackson and Jeb Stuart was sort of a smushed version of that. The others, though, in one form or another, may or may not have had the famous symbol. So to talk about the Confederate flag is really a misnomer. There were a lot of them. And, no one really gets excited if somebody flies the Hardee's Corps flag or the Bonnie Blue flag unless they're a historical aficionado. But all these are associated with the Confederacy. All the hullabaloo, though, is associated with the Army of Tennessee's flag. Okay. Now, there was no judicial precedent at the Supreme Court level until after the Civil War. But then, in 1869, Texas v. White was handed down, and the court said, look, the states they thought they were part of the Confederate States of America, they were wrong. They were still part of the United States of America. There is no right to secede. You cannot secede. So even during the Civil War, all those states were still in the Union. But that was after the fact. And to this day, Texas v. White is still on the books under the proposition that the secession movements were ineffective. You cannot secede. So was it treason? Was it something else? After the Civil War, the flag was widely displayed, all of the Confederate flags. And they would have reunion events. Veterans of both the North and the South would get together and have picnics and maybe little reenactments. And not infrequently, there'd be some controversy. Some of the Union veterans would object to sharing the field with people who were flying the flag of treason, as they called it. And sometimes there'd be fights breaking out. Obviously, people still felt very strongly about this. A lot of people fought and died, about 750,000 casualties. And so it was a magnet for controversy even back then. Well, gradually, portions of the Confederate flag were added to some state flags, and other southern states would fly the Confederate battle flag in addition to Old Glory, but not in lieu of it, and always lower than it. And there's innumerable statues, monuments, cemeteries, historical sites that include either the flag or other Confederate iconography. So if it's treason, then it could be an exception to the First Amendment, but it seems unlikely that it could be treason given the fact that there was no clear precedent to the contrary. The Constitution doesn't prohibit it, and even New England states assumed that you could secede. Is it incitement or fighting words? I'm rapidly running out of time, but very briefly, both Chaplinsky v. New Hampshire and Brandenburg v. Ohio typically are understood as requiring some sort of immediate in-person encounter, like a KKK rally or an argument in the street where there's a danger of something happening right then and there, imminent lawless conduct. And displaying the flag, well, I suppose in the right context it could be incitement or fighting words, but if you just keep it on display long term, there doesn't seem to be that imminence, that immediacy that's typically understood as going along with those two cases. And really, bottom line, the exceptions are typically understood as being read narrowly, not broadly. You don't want to have the First Amendment swallowed up by these exceptions, so you don't want to apply the fighting words doctrine beyond its immediate facts. At least that's typically been the norm. This became, of course, controversial with the mass murder recently of 9 innocent African Americans by Dylan Roof, who apparently wanted to start a second civil war. And then there were several photos of Roof with the Confederate flag that went viral. And of course, as a result of this tragic event, there was a lot of public pressure to remove the flag, to ban it. It was taken down voluntarily by Governor Nikki Haley in South Carolina. It previously had been flown in various state buildings. Of course, no one wants to see a repeat of that kind of atrocity, but the flag has been sort of a magnet for a lot of the desire to do something with this. Now, there's other controversial symbols too, like the swastika. The swastika, like the Confederate flag, is susceptible to varying interpretations. And before Adolf Hitler and the National Socialists took it, it went back thousands of years in a positive context to ancient and modern civilizations. And so, which meaning of the Nazi emblem should control? Should Hitler have rendered it off limits forever, even though Buddhists and Hindus and Jainists still use it and consider it a very positive emblem of their religion, etc.? Same thing with other symbols. Symbols are tricky things. They can have various meanings, like the ones mentioned there at the bottom. You raise the wrong finger, you wave your left hand, you cross your legs in public. That could be viewed as very offensive by some people. Other people would think nothing of it. So what are you going to do? These are just some examples of the swastika. This, of course, is the Nazi version, but you have the Dalai Lama with the swastika. No one's ever thought he was a Nazi. Buddha himself. Amazing variety of cultures that have and continue to use the swastika. So should it be banned? Certainly it has a very tragic modern connotation. Does that mean you can't use it for anything else ever again? There are even current secession movements in this country. Hawaii, once in a while, maybe under a last in, first out theory, people want to become free and independent again, but not so much that, but these nullification movements, voting to accept yourself from federal law. The Federal Controlled Substances Act makes marijuana an illegal substance even to possess. Well, then under what authority do these states vote to legalize it? What about the 200 plus sanctuary cities that have voted to not enforce federal immigration law? If we consider secession to be treason, maybe these modern secession/nullification movements should be viewed as treasonous as well. Despite the fact that there's the supremacy clause, we have all of these movements to carve out exceptions to the federal law. And hence the cliche, if at first you don't secede, try again. My conclusion is, bottom line, the remedy we've always defaulted to for controversial, hateful, inflammatory speech isn't to suppress it, isn't to ban it, isn't to censor it, but to expose it with more speech, with counter demonstrations, with arguments. And the best disinfectant is sunlight. Don't try to ban it. If you try to ban it, perversely, you'll focus more attention on it than it deserves. And we're heading in the exact opposite direction with what is currently happening with regard to the Confederate flag. At this point, I'm going to turn the time over to my opponent, and then we'll take some questions.
Good afternoon. Good to hear what you had to say. I'm not sure we're opponents.
Okay.
All right? Here's what I propose to do in the 15 minutes I have. I'm going to start off in the stratosphere with some conceptual notions of what flags are. And then I'm going to talk a little bit, as my colleague did, about the First Amendment. And then finally talk about the most recent Supreme Court decision dealing with the Confederate flag, maybe the only one, and that is the Walker case. So, stratosphere first. There's more than one Confederate flag, as you know, thank you. this working? There is more than one Confederate flag, as you know, but stripped to its essence, a Confederate flag is a rectangular piece of cloth with the colors red, white, and blue arranged in stars and bars. Standing alone, the flag lacks any meaning. Possible meanings emerge only when this piece of cloth is seen and interpreted, just as the meanings of markings on a piece of paper arise only when they are apprehended as words in a language. Like the interpretation of such words, the meanings attributed to the Confederate flag depend on what the viewer brings to the activity of viewing. The piece of cloth can yield aesthetic meanings by virtue of its shape, color, and design. Similarly, viewers are likely to perceive cognitive and emotional meanings from the cloth and its symbolic configurations. To use a fancy term from semiotic theory, in semiotic terms, the Confederate flag is a signifier, and the various aesthetic, intellectual, and emotional meanings that may be attached to it are signifieds. What is signified by the Confederate flag has no natural or necessary relationship to that signifier. Rather, what is signified by the Confederate flag is solely a function of socially created conventions. Just as words have no meaning apart from the conventions of the language in which they appear, and apart from their relation to other words in that language, the Confederate flag similarly has no meanings apart from those conventionally given to it by those who see it. In the case of the Confederate flag, many conventionally agreed upon meanings have not only intellectual content, but emotive content as well. Many Americans feel strongly about the Confederate flag, some seeing within its borders a patriotic and historical symbol of the Confederacy, while others see it as an anti-American symbol of white supremacy, hate, and racism. The ultimate inquiry into its social meaning depends in large part on the interpretation most viewers ascribe to it, perhaps even irrespective of the meaning the particular person displaying it intends. More about that later, I am sure. A few things about the First Amendment and then about the Walker case. Congress shall make no law abridging the freedom of speech or of the press, and there are generally thought to be two primary rationales of the First Amendment. One is the marketplace of ideas rationale, which is fairly self-explanatory, kind of laissez-faire approach to ideas. Willing buyers, willing sellers, you buy and sell what you want. The other idea, more closely connected to the Constitution, if you will, is the rationale of self-government. We need speech, especially political speech, in order to govern ourselves. Now, as I move into the Walker case, which deals with specialty license plates and a Confederate flag design rejected by Texas, I want to tell you about two lines of First Amendment cases that are in tension in the Walker case. It turns out to be very important where speech takes place. The fancy terminology for that is forum analysis. Where does the speech take place? And where the speech takes place determines whether and to what extent government can engage in what we call content discrimination and viewpoint discrimination, singling out certain content, certain views for disadvantageous or perhaps favorable treatment. For example, streets and parks are what we call traditional public forums. And in those streets and parks, all of us have a First Amendment right of access to market our ideas. Government cannot in these traditional public forums remove particular subjects or viewpoints from these, as I say, traditional public forums. This gets even more complicated than traditional public forums. We have got designated public forums where government opens up, say, a municipal theater, or where government opens up a railroad station or a bus station, as if it were a traditional public forum. Limited public forums, other public property. The conventional understanding of the First Amendment doctrine in all of these kinds of public property is that government cannot discriminate, at the very least, on the basis of your viewpoint. Sometimes government can remove certain subjects from a designated or limited public forum. Government, if it owns a municipal theater, for example, could show only Shakespeare in that theater if it wanted. But no viewpoint discrimination. Government cannot single out particular views that it finds offensive and say no right of access. So, to bring this back to the Confederate flag, if a private person wishes, for example, to march in support of the Confederate flag in a public place, he or she cannot be prohibited from doing so solely by reason of the view supposedly communicated by the Confederate flag. Now, there is more to this that we need to get into in order to get into and understand the Walker case. This is a relatively recent phenomenon in First Amendment jurisprudence, and it is called the government speech category. Because while government is disabled in many situations from regulating our speech, government itself often engages in its own speech. And think about it. Isn't legislation speech? Don't we want government officials to espouse certain viewpoints? That's what we elect them for. And here is the key First Amendment point about government speech. Government is, when government speaks, there is no First Amendment analysis whatever. There is no First Amendment analysis whatever. And to bring this back to the Confederate flag, if the United States were to display the Confederate flag in public places, were states to display the Confederate flag in public places, that's government speech. Is it viewpoint expression? Of course it is. Government can express its own views. It's only when it comes to regulating the views of those of us in the private sector that government is often disabled by the First Amendment. So you've got that. Now you've got form analysis, where the speech takes place, and then you've got government speech. And you can begin to see, if you're at all familiar with the Walker case, where this arises. Texas offered automobile owners a choice between general issue and specialty license plates. Those who wanted the state to issue a particular specialty plate could propose a plate design comprising a slogan, a graphic, or both. And the Texas Department of Motor Vehicles Board had to approve the design, and if it were approved, if it was approved, the state would make it available for display on vehicles registered in Texas. So that, for example, there were specialty plates that honored colleges and universities, specialty plates that honored the Masons, the Knights of Columbus, the Daughters of the American Revolution, realty companies, favorite soft drinks, favorite burgers, a favorite NASCAR driver. Okay? These were on specialty plates. In this particular Walker case, the Texas Division of the Sons of Confederate Veterans filed suit against the chairman and members of the board because the board had rejected a Confederate battle flag for its specialty plate design. And it did so because, expressly, the board did so because this design would be considered offensive by many. The case came up before the United States Supreme Court, and the issue was posed in terms that I have hinted at already. Is this design on the license plate, the Confederate flag design, is it private speech? And if it is private speech, the government has to allow it on its license plates, because otherwise the government would have engaged in impermissible viewpoint discrimination. The other question, the other side of this was, well, maybe this speech, the Confederate flag, is maybe what's on these specialty plates is not private speech, but it is all government speech. And if it's all government speech, then government can say what it wants and refuse to say what it doesn't want to say. And it doesn't want to say Confederate flag and sons of Confederate veterans on it. 5-4 decision. It was viewed by the majority in an opinion by Justice Breyer as government speech. And since it was viewed as government speech, the government was allowed to turn down this particular design because it was not consistent with the government's own views. And the court said it's government speech because it looked at the history of these license plates and pointed out, among other things, that what's on the license plates would often be identified in the public mind with the state. And Texas maintained direct control of these messages on its license plates. And finally, the board had final approval of these designs. This was not, therefore, a traditional public forum. These specialty plates were not traditional public forums. They were not designated public forums. They were not limited public forums. They were not even government property to which private persons had access. 4 justices in dissent, Justice Alito, and he argued that the majority opinion is a bit ridiculous because, in his view, people looking at the slogans and designs on these specialty plates seldom, if ever, would identify those as the state's message. Remember those examples I gave you? The Masons, colleges, Knights of Columbus, Daughters of the American Revolution, favorite soft drinks, and the like. He said this was a classic case, in his view, of governmental regulation of private speech, and the government had opened up this property, this public property. Government owns the license plates. This public property for private speech, and therefore it was not allowed under the First Amendment to discriminate on the basis of viewpoint. So there you have it with the Walker case. A couple of final comments. Think about this. If, in fact, the dissenters are correct, and it's a very close case, it's a hard one. A lot of states have these specialty plates. Think of what a decision by the court to the effect that these specialty plates are essentially enabling private speech. The state would be faced with either allowing some of the most offensive symbols, a swastika, right? Nazi flag on a license plate, a Nazi emblem, symbols and like, would be faced with that. Or what could it do? It could say, we are not going to allow any messages. We're not going to allow any specialty plates, whatever. Notice when the government does that, It's basically saying we're not discriminating at all. So I think that was an underlying motivating factor for the majority. The majority must have been sensitive to the fact that if Alito and the other dissenters were right, that would spell the end of the specialty plates in the states. There you have it.
Because we're almost out of time and we want to allow some time for Q&A, we have about 5 minutes if anyone wants
We
to.
can just go right into the Q&A now.
Yeah. Does anyone have a question for either of us or a comment? Too much pizza? Not controversial? Okay, there we go.
What your viewpoint would be, say a high school says that students can't wear Confederate flag symbols to school, whether or not that would be allowed or not?
Let me just briefly chime in. Under Tinker and a lot of other cases, K through 12 education are in a separate category where the school administration is given a lot more leeway in restricting, say, teachers with any message or certain messages than in any other setting. So I would say clearly a school would be within its rights to prohibit the flag under Tinker and other related cases, just because of the need of discipline and good order in the school setting.
That's a tough one, actually. I tend to agree with what you're saying. The test in the school situation is whether the school can reasonably predict material and substantial interference with school activities and discipline. So clearly, in this particular situation, if the school doesn't have that prediction to make, then that would cut in favor of the students doing it. But also, it's clear that this school could not really discriminate on the basis of the particular message. And yet, a kind of in loco parentis with respect to schools and elementary and secondary school students. I suspect this Supreme Court, despite Tinker, would allow, your conclusion, would allow that. That's my guess.
Good question.
Good question, though.
Anyone else?
Should we ask you questions? We're both teachers. We can engage in Socratic dialogue here. Anything about the First Amendment?
I guess we're done.
Okay.
All right, well, thank you
Okay,
so
Chris,
much.
thank you. Okay, that's good.
Thank you all for coming. Please feel free to grab some more pizza, and please be on the lookout for future events from the Federalist Society.